Good afternoon to you all. Thank you for your patience and indulgence to allow more participants to get onto the call, but we need to start so that we can be able to finish on time today. So once again, a warm welcome to you to the second bootcamp. And basically this one is our memorial writing, and this is the bootcamp on written submissions and memorials bootcamp. And without wasting time, I will be your first facilitator. My names are Freda Nalumansi. Like I introduced myself yesterday, I lead the research and advocacy department at Unwanted Witness, and as well as doubling as the head of the Moot Secretariat. So thank you so much for yesterday's participation, and we are looking forward to another engaging session today. A warm welcome to our facilitators, the rest of the team and colleagues who will be joining me to facilitate this bootcamp today. We have Miss Rufaro from all the way from Zimbabwe. I would appreciate if we can give her some virtual claps for her. And we will also be having a colleague from SOKI Initiative, and this is Mr. Kasivante. I don't know if they are on the call, but it would be nice if we can just give them some shouts, some claps, virtual claps to welcome them on board. Yes, David, you're most welcome. Thank you. Could you just say 1, 2 words just to greet our participants in 1 minute? And then we can also have Rufaro greet our participants.
Yes, thank you very much, Freda, for that warm welcome, and for the team at Unwanted Witness. Thank you so much for organizing this this meeting, this event. I am very glad to be here and to facilitate, partly facilitate this session. I'm very excited to be here. I have worked with Unwanted Witness for a while. Those who have engaged with Unwanted Witness before, you probably remember me as one of the judges at the different moots that we have had. So it's more than a privilege to go from behind the bench to now, you know, pass on some skills and advice on how to basically succeed in memorial writing. So thank you very much, and I'm glad to be here. So Freda, I think you're muted. I think you're muted, Freda. You can see you speaking, but your mic shows it's muted.
Sorry, Rufaro, could you come in and greet our participants in 1 minute?
Hello, ladies and gentlemen. Thank you so much, Freda, and the Unwanted Witness team for inviting me. It's my pleasure to be part of this bootcamp. I'm so excited to listen in and also share part of my experience in legal writing, and the part that I've been assigned to assist with and facilitate. Thank you so much once again.
Thank you, Thank you, Rufaro. So, ladies and gentlemen, to continue, our first module is to introduce us to memorial writing and its importance. And I will be taking you through this module quickly. So, before we get into what our first module is all about, this bootcamp basically aims to equip you with skills required to draft compelling, well-reasoned, structured memorials for the Unwanted Witness Moot Court Competition 2025. So as mooters, you will gain practical insights, research, argument development, formatting persuasive writing techniques, crucial for your written submissions. So why does mooting matter? Mooting hands legal reasoning, advocacy, teamwork, preparing for your real world challenges. Like some of the issues that we saw in the cases that we shared yesterday across the different countries. And I remember yesterday mentioning the case of WorldCoin case from Kenya that was recently decided. The main goal of this bootcamp today, this afternoon, is to build your confidence, refine writing skills, and connect with other mooters across East Africa. Mooting is not just a competition, it's a critical tool that helps you to shape you as fearless advocates. So it is my hope that you all are inspired as participants, as participants of this competition, to embrace mooting as a transformative experience for you as you continue to journey with your legal studies, and until when you will be done and you'll be ushered into the real world, where you will be dealing with legal issues, litigation, and having to present submissions before your judges in the real world. So in terms of our presentation, my presentation this afternoon, we will be introduced to what moot memorials are all about, the significance of the memorials, especially in this competition, the role of memorials in advocacy and case presentation, how judges assess written submissions, some practical tips for memorial writing, and then we will close. What are moot memorials? They are written legal submissions of briefs that teams present their arguments, legal reasoning, and authorities for a hypothetical case or issue that you would ordinarily interface in a moot competition. The purpose of these memorials are to clarify arguments, articulate your case legal and factual basis with the judges before your oral rounds. So basically, the memorials that you will be preparing, you will be the very memorials that you would be making submissions against during the oral presentations in September. Memorials help you to demonstrate research. This is the time for you to sharpen your research skills, especially in terms of on how you engage with statutes, case law, international authorities, how you're able to dig into these documents, and then also be able to apply them and interpret them and show mastery in all these aspects. it also helps to set the stage. The memorial will help you to frame the dispute and help you to guide the judges on your interpretation of the moot problem for them to be able to make an informed decision at the end of the day in terms of the case that will be before them. So in our context and also in the previous moot editions, generally our privacy moots tend to address various issues like biometric data misuse. It could be something that is informed by a case that was heard before a competent court, and maybe it was a landmark case. Obviously, depending on the issues that were raised and what is going on in the region, they would inform some of the issues that we address. In previous competitions, more recently in 2024, the issue that was addressed was safeguarding electoral integrity, upholding voter privacy in democratic elections. In 2023, the moot issue was on surveillance, particularly on balancing privacy rights and national security, navigating the impact of the laws on individual freedoms. Then in 2022, which marked the first edition of the Unwanted Witness Privacy Moot competition, the issue that was addressed at that time was online transport app. So you can see they are varying issues, and they continue to grow, obviously, as also the issues unfold around data privacy and data protection, and obviously with the uptake of technology in the region. So memorials are often weighed equally with oral arguments. And for my presentations, I would really heavily rely and draw your attention to the moot rules, which you already have access to on the website. And the memorials contribute 50% of the total score. So which makes them very critical for your success. So, and this time around, I can't help not to emphasize the fact that the memorials this time in this edition are very critical. You must have a good mark that should put you in the first 4 top memorials in each country for you to be able to qualify for the national rounds. I can't emphasize this enough. Your ticket to the national rounds is going to be actually the memorials, your memorial, and you should have got top marks, the highest marks. So we will be taking the highest 4 marks in each country for you to be able to qualify for the national round. So pay attention to your memorials. Pay attention, I can't emphasize it enough. Pay attention to your memorials. Make the rules, the moot rules, as your guiding principle, the way you would, the importance you attach to a Bible or a Quran would be the same importance, because the rules are the ones that guide the competition, and they have provided for every aspect of the competition from the roadmap to your dressing code, to the memorials, to the oral presentations. Penalty marks will be given for non-compliance. So I can't emphasize your memorials enough, because this is your entry point. This is your ticket to the national rounds. Ladies and gentlemen, let's continue. Significance of memorials to the competition, to the moot competition. So why memorials matter in a competition? Persuasion. The core functions include persuasion to be able to convince judges of your position through clear logical arguments, professionalism, to reflect your team's preparation, attention to your decorum and legal acumen. It's a foundation for orals, and it will serve as a roadmap for your oral arguments and consistency. High-scoring memorials can secure awards and advance the team in other rounds. Memorials as tools of advocacy. In terms of the advocacy role, the way you structure your arguments, they organize claims. You organize your claims into issues, okay? For example, the jurisdiction, the issue, the rule that is applicable, and then you would conclude to persuade. Then anticipate counter arguments. So you should be able to explore what the other side would advance. So you address those opposing views in especially whether you're acting on behalf of the state or the other party. It also builds credibility, cite authoritative sources. For example, like the constitutions, all the participating countries have constitutions as the law of the land. That is a good point to start from before you get into the other legal instruments. Case presentation, narrative, craft compelling a story of the dispute that is humanizing your client. Or citizen that is harmed by unconsented data sharing. Use concise language and headings to guide the judge through what you are talking about. Memorials amplify advocacy by giving voice to those who are marginalized, giving marginalized perspectives. And I have some examples there that I'm citing. For example, in the Nubian community, is in the Hudima case number, where we had but obviously over-reliance on legal jargon would obviously throw the judges off board. So of late, we moved from that era where we used to speak a lot of those jargons, those heavy legal terms, and we are being encouraged to use simple language. So memorial tells the court not just what you think, but what justice demands at the end of that day. And with this, quote from Cloney, it highlights the memorial's role in blending the law with advocacy. I wanted to share with you a structure, the Iraq structure of how your memorial generally should look like. So you have the issue, and under the issue, you'll ask yourself, what is the legal issue? Then we have the rule, what is the law that applies? Then application, how does the law apply to the facts? And then you would conclude, what is the outcome? How judges, so the next is on how judges assess memorials. Basically, this is rooted in the moot court competition rules. Specifically, I'll draw your attention to chapter 4 from Article 24 to 26. And I have a summary here for you on what's the parameters that the judges will generally apply to either whether you are appearing as an applicant or as a respondent. They would look at your knowledge of the relevant laws and legal principles that carries 25 marks, knowledge and application of facts that carries 25 marks, organization, so organizing your information, the structure and analysis of the issues, which carries 15 marks, the use of authorities and citations, which carries 15 marks, persuasiveness, ingenuity, logic and reasoning, which carries 10 marks, and obviously grammar, style, clarity, also carrying 10 marks to a total of 100. So I would want us now to dig in quickly on understanding the moot problem, okay? So our hypothetical case has already been shared with you on the website, and you should have an interface with it already. So the hypothetical case is by Uhuru Kwafaraj versus the Republic of Azimia. And this hypothetical case presented for this year's moot revolves around a challenge to a national identification system in the fictional Republic of Azimia, a member of the East African community. The case raises critical questions about balancing state interests, security and public service delivery with the protection of individual privacy rights. It draws inspiration from real-world debates surrounding biometric identification systems, data protection and governance in regions with evolving legal frameworks such as East Africa. To guide you on understanding the case's implications and requirements without providing direct mooting strategies, we will look at the following. So there are 4 areas that we are going to look at. One will be the implications. So we are going to look at the implications for individuals' rights or right to privacy. In this case, Azimia's national identification system, which mandates the collection of sensitive biometric data, in the form of iris scans and facial recognition without adequate safeguards, poses significant risks to individuals' privacy. The key implications are in the form of invasive data collection. With this, the mandatory collection of biometric data, which is uniquely identifiable and immutable, heightens the risk of privacy violations. So without clear communication or consent mechanisms, individuals lose autonomy over their privacy information. The other implication is in the form of risk of misuse and breaches. And the absence of robust security protocols and a history of data breaches in Azimia increase the likelihood of unauthorized access, identity theft, or even exploitation of personal data by state or non-state actors. Then the other implication is in the form of lack of transparency and consent. Citizens lack information about data collection or storage, and sharing and sharing undermines their ability to make informed decisions, obviously at the end of the day violating the principles of informed consent, which is central to privacy rights. The other implication is the disproportionate impact on vulnerable groups. while the systems aim to promote inclusivity, the lack of safeguards could disproportionately harm marginalized populations. For example, persons with disabilities, elderly persons, who may face barriers in understanding or challenging any instances of misuse of their personal data. The other impact or implication is in regard to the chilling effect. The combination of opaque governance and potential surveillance through biometric data may deter individuals from exercising other rights such as freedom of expression, association, due to fear of monitoring or retribution. So as such, at the end of the day, you as Mooters should focus on how these factors interact with legal obligations under the East African Community Treaty and the broader human rights frameworks, balancing individual privacy with the state's objectives of security and service delivery. I would like now for us to break down the moot problem further in terms of, we will, in this, we are going to look at the key factors, legal issues, and the stakeholders. So in terms of key factors, Azimia's National Civil Identification Commission launched a mass registration for a new national identification system using biometric technologies, like I earlier intimated, iris scans, facial recognition, to modernize infrastructure, enhance security, and improve service delivery. The other important aspect of the facts is the non-compliance with data protection impact assessment. So the program for collecting the data began without an impact assessment, and yet it's a legal requirement under Azimia's data protection laws. And obviously, there was no opportunity to evaluate the risks of processing this data. Then the other pertinent aspect still on facts is the lack of transparency. Citizens were not informed about data collection or even possible sharing third parties. No public privacy policy or frameworks exist to clarify on sharing or even sharing agreements or even safeguards in place. Then the systemic vulnerabilities. The 2022 Auditor General report highlighted key information, including data migration strategy, inadequate safeguards, and past government systems have also experienced data breaches. Then for the legal action, Uhuru kwa Frank, a civil society organization, filed a case at the East African Court of Justice alleging violation of the East African Community Treaty's principles. So here you look at the rule of law, good governance, and human rights. Let's go to the legal issues. So in terms of the legal issues, we have the non-compliance with the data protection impact assessment, which is a requirement in the law of Azimia. So the question here would be, does Azimia's failure to conduct a data protection impact assessment violate its obligations under the East African Community Treaty, particularly regarding human rights and good governance? Does the mass registration without adequate privacy safeguards infringe on citizens' privacy rights under the regional treaty, the East African Community Treaty, and international legal frameworks? Do Azimia's actions breach East African the East African Community Treaty principles of good governance, transparency, and accountability. And what measures should the East African Community, the East African Court of Justice recommend to ensure compliance with data protection and privacy standards? In terms of the stakeholders, we have Uhuru Faraj, who is the plaintiff, a civil society organization advocating for rights. For privacy rights, representing citizens' interests. The other stakeholder is Republic of Azimia, who will be the defendant responsible for the national identification system, defending its initiative as necessary for public interest. Then the other is the citizens of Azimia, directly affected by the program, particularly vulnerable groups, like I intimated, elderly persons, persons with disability, and whose privacy and data security are at risk. The East African Court of Justice, which is the judicial body tasked with interpreting the East African Community Treaty and adjudicating the dispute. The East African Community, which is the regional body whose treaty principles in terms of rule of law, human rights, and governance are invoked, and the civil society and privacy advocates, broader stakeholders raising awareness about privacy risks and supporting the plaintiff's case. So as participants in this competition, you must analyze how these facts and stakeholders shape the legal arguments on the interplay between state obligations and individual rights. I want to quickly run to core privacy and data protection legal principles and quickly delve into them. We did look at this generally in yesterday's bootcamp and presentations across, and some of these principles relate to lawfulness, fairness, and transparency, purpose limitation, data minimization, security, and integrity. Informed consent, accountability, the right to privacy, good governance, and rule of law. So as participants, you should use these principles to frame your analysis, ensuring that your arguments are grounded in legal obligations, under the East African Treaty and the relevant frameworks. Lastly, I would want us to distinguish between the relevant legal arguments for both sides. So while specific arguments are not provided, participants must distinguish the type of legal arguments each side may raise to address the legal issues. These arguments should be rooted in the East African Community Treaty, Azimia's data protection regulations and broader human rights and data protection frameworks, and for key considerations for each side. For Uhuru Faraj as the plaintiff, focused on violations of privacy rights due to the lack of the data protection and impact assessment, transparency, and safeguards. Emphasize breaches of the East African Community Treaty principles, in relation to human rights, rule of law, and good governance. Highlight risks to citizens from data misuse, breaches, and lack of consent supported by Azimia's history of poor data management. Argue for remedies to protect citizens, such as halting the program or mandating compliance with data protection standards. In the case of the defendant, who is the Republic of Azimia, defend the national identification system as a legitimate exercise of state authority to achieve public interest goals like security, service delivery, inclusivity, and any others that you would come up with. Argue that the program aligns with the East African Treaty objectives such as economic development or regional integration, address the data protection impact assessment of mission by claiming alternative measures or ongoing efforts to comply with data protection requirements. Propose that any violations are not severe enough to warrant judicial intervention, or that remedies can be implemented without halting the program. So as participants of this competition, you should explore how these arguments interact with the legal principles and facts, ensuring a balanced analysis that respects the court's jurisdiction under the East African Community Treaty. Ladies and gentlemen, this ends our first presentation. And at this juncture, I would like to invite any questions so that we can quickly get into the next presentation. So do we have any questions in the next 1-2 minutes? Because we are really trying to make sure that we keep time today as much as we can. Do we have any questions? Consulate, yes?
Yes, can you hear me?
Yes, we can hear you.
Thank you for this opportunity. My name is Consolata Maida. I just have 2 questions. Maybe I missed it because at some point you're breaking. Do you have minimum number of words that the memorial should carry? That is my first question. Number 2, what is the format of reference that is preferred for the memorials? You're on mute, Freda. I can't hear you.
Allow me to stay those questions because we are getting into the next presentation that is going to be talking about structure and the format of the memorials. But for purposes of just killing your curiosity, it's 10 pages, okay? I see Musonera, yes?
Yes, good afternoon. My name's Innocent Msonera. Thank you, Freda, for a very good presentation. I don't have a specific question about the presentation because I think you did it well. Mine is simply about whether it is possible that the organization of this competition can share with the participating teams any best memorial from the previous editions, if that is possible, if you've been keeping them. Thank you.
Unfortunately, that is not possible. Given the nature of the competition, we are not privy to do that. There was someone who asked about marks. I want to get, I don't know if this question was in the chat. I need I need clarification on that. I'm trying to trace it. But if I don't see it, so someone is asking about citations, reference style. All this will be, we are going to handle in the next presentation. So kindly just pack some of those issues in relation that relate to formatting, structure of the memorial. We are going to discuss them in the next presentation together. In terms of marks, let me just bring back my earlier presentation and we quickly go to that slide that talks about the marks, the criteria of, so just give me a second as I bring back I just want to share just a quick reference on so the person who was asking, I don't know if they came in late, but the memorials when they are being marked, the judges look out for issues in relation to knowledge of the relevant laws and legal principles, knowledge and application of facts, which carries 25 marks, organization of your information structure and analysis of the issues is 15 marks, use of authorities and citations is 15 marks, persuasiveness, ingenuity, logic and reasoning, 10 marks, grammar, style and clarity is 10 marks. So this is how your memorial generally will be marked. So allow me quickly, ladies and gentlemen, to please move to the next. Allow me to move to the next presentation if we do not have any other questions. When I see a question on when is it exactly that the date for submission of these memorials. Okay, this we shall also discuss in the next module. That will form the crux of our discussion as well. Yes, Jonathan. Jonathan, yes, you're the last. Yes.
Thank you very much for the opportunity. And thank you for the very good presentation that you've done. Mine is a question. When you look at the East African legal framework, realize that we have no specific instrument that speaks on data protection impact assessment, as well as some of the issues touching on privacy and such. So are we to rely on the national instruments for each country while doing the national rounds? Or which particular instrument specifically with regards to the issue of the data protection impact assessment are we to rely on?
The aspect of data protection and impact assessment is actually covered in the national legislation on data protection and privacy in the different East African countries. Just once you're at it, study them, and you will come across some articles, sections, and that will be speaking about it. They are those that actually have it. Okay, so please allow me to move into the next presentation, but also I want to draw your attention to the rules, the moot competition rules as one of your guiding documents. I can't emphasize that enough. If you've not been paying attention to them, now is the time. And beyond the bootcamp, please create time, sit down, read these rules comprehensively so that you are able to comply. And in that way, you will avoid penalties. But if you don't pay attention to these rules and you do as you wish, you are going to earn yourself penalties. So ladies and gentlemen, allow me to quickly pull up my other presentation so that we can move. Give me one. Okay. Are you able to see my screen?
Yes, we are.
Okay, good. So basically, my second presentation is on structure and formatting a winning memorial. But in the interest of time, I would like to refer you to the rules because the presentation is actually on basically what we expect you to do. And the structure and the format of the memorials is well provided for in the rules. So I wanted to skip this presentation which basically covers the aspects of your cover page, what your cover page must contain. It should not, like earlier on yesterday, I told you that you're using your unique identifier number or code. You do not use your names. You do not use university names. You only identify yourself as per the code and as either counsel for applicant or counsel for the respondent. And obviously the number of pages don't exceed 10. They should be 10, not anything beyond that. The front cover pages must be color coded according to, if you're an applicant, it should be yellow. If you're a respondent, it's green. So all these things are provided for in the moot competition rules. So ladies and gentlemen, I will share this presentation, but basically you can also refer to the moot court rules for aspects pertaining on the structure, pertaining to the structure and what you will be subjected to for non-compliance. So you can access the rules on our website, www.uwmoot.com. Please get to that website, download a copy for yourself, and as soon as we are done, not even before we actually finish, when you go back home today, please take time off and study these rules because the things that we are talking about are actually guided by these rules and they are our guiding principles for the competition. So if you want to make sure that you don't lose any mark in form of penalties for non-compliance, please, I can't emphasize enough, read the rules. At this juncture, I want to stop here in the interest of time. I want to invite our next presenter, who is none other than Mr. David Kasibante, to take us through modules 3 and 4. Mr. Kasibante, you're most welcome.
All right, thank you so much, Freda, for that presentation. It gives a good foundation for what I'm going to discuss. So unfortunately, I do not have a presentation like PowerPoints and everything. So I would
David,
request that
sorry,
everyone, yes, please.
David, your volume seems to be very low.
Okay.
Yes,
No,
if you could just increase it.
okay.
Thank you.
No, I was speaking very low because I'm alone where I am, so I didn't want to shout. But am I more audible now?
You are, at least
All right.
me from
Thank you
my
very much.
end.
Thank you very much. So as I was saying that I will be requiring you guys to like pay very keen attention. If you can take some notes, please do. But the purpose of this of these two modules is, one, to give you an introduction, a little introduction to legal research, and what would be expected of you when you are doing legal research. Okay. And then how to turn that research into persuasive and concise arguments. Okay. So these two are the bread and butter, or the gist of your memorial. Now, my understanding is that most, if not all of us here, have had a brief introduction to legal research. So we kind of have an idea of what that should look like, right? Where to look, how to look. So most of the things that I'll be talking about will sound familiar. But remember that when you're conducting legal research, especially for a moot or even for an exam, there are certain tips and tricks that would set one memorial apart from another. Okay. The difference between someone who gets a 60 and someone who gets 70 oftentimes just goes down to this. Okay. So let's start with the concept of legal research, okay, and case law analysis. Now, right under this, I would start with the concept of effective legal research methods. How do you conduct legal research effectively? What methodology do you choose? The methodology will basically be how you arrive to your conclusions, okay? And the methodology that you take will often determine the quality of the outcome, okay? So, one, the best way to go about legal research is to identify your primary sources and your secondary sources. Now, legal research is largely doctrinal. Doctrinal meaning that it often does not involve you going to the field and conducting interviews and that kind of thing. No, it's often black letter, okay? Sit down, open the books and let the books speak. So you will be looking at two key sources, legal sources. First, the primary sources, then you have secondary sources. Primary sources are those things which are cast in stone, they are set in stone, okay? They are typically set in stone, they are typically unchangeable per se, and not subject to much review. okay? And your most important primary sources in this instance, those would be the Constitution, okay? Data Protection and Privacy Act, the Computer Misuse Act, laws basically, okay? Case law, treaties and instruments, okay? Those would be primarily your primary sources. Then, after that, you then look at your secondary sources. Secondary sources typically expound on the primary. So you may have articles, written articles, commentaries, reports, for example, from UCC or NITA, you know, international guidelines, the OECD privacy guidelines, those would be good, you know, for that, you know, approach. But as you're doing all of this, you need to understand that your primary motivation is to understand how these laws and commentaries intertwine and interoperate. Okay? How is the Constitution supported by the law? All right? Or how is the law supported by commentary? Okay? That interoperability is what we'd be looking for. Now, when you're going to research, you typically would take a hierarchical approach. Okay? You typically will start with the constitutional provisions. Okay, what does the Constitution say about this particular thing? Especially if you're in Uganda, if it's a national mood and you're trying to, and the source of law, the sources of law within the problem are national in character. However, if it is not a national mood, i.e., if from the question, your forum of interpretation of the rules is not a national court, okay, then it would be advisable that you start with the treaties instead, okay? If it's a national court, let's say Uganda, the constitution is the supreme law. So start with the constitution. If the question says the court is not in Uganda, East African Court of Justice, it is African Court or ICJ or any other international forum that's not in Uganda, then it is advisable that you start with treaties. Okay? Now, if it's a national court, start with the Constitution, then look at the statutes and regulations, you know the hierarchy of laws. Okay? Then case law, or any customs, and then you look at regional instruments and international standards, and then you supplement all of this with some secondary sources. However, it's from an international court, then you would start with the treaties themselves, any customs that exist. It's like you're going back downwards, okay? Any customs that exist, then constitutional provisions, and then statutes and rules and that kind of thing, okay? That approach allows you to properly structure your arguments, starting with the strongest to the weakest. Okay, so for example, if you're researching a data breach, a case against a Ugandan, let's say, telecommunications company, you typically start with Article 27, of course, of the Constitution. Then you want to examine the specific provisions in the, you know, the DPPA regarding security obligations, data security obligations. Then you probably go to the Ugandan cases on corporate data breach, okay? And then finally, you'll probably look at African jurisdictions and how they have handled similar cases or international jurisdictions, right? If it was an international forum, you probably want to start with the guiding treaty that that state has signed, and then you condense it down to the national laws and any other principles at the national level. Okay. That said, let's look at using online databases and research tools. There's quite a number of these. And I believe that you have probably already interfaced with some of these, you know, ULI, Uganda Online Law Library, the Parliament of Uganda's website, and it's good for legislation, the UCC website. Okay, at the regional level, you probably have the ESCJ, you know, database. Okay, and then some international resources as you may see fit. Okay, and as you're doing all of these, when you're researching using these online tools, I would give you some tips on how to find information faster. All right. One, try to use what we call Boolean operators. Okay, and or not. Okay, those are Boolean operators. If you're doing a Google search, they could help you come up with information faster, right? You can use quotation marks. Some of you don't know that when you search Google with quotation marks, you're telling it to search for that specific thing. Okay, it can help you. You can also focus on some jurisdiction specific terms, something that is specific to that jurisdiction. Okay. You can also kind of, I don't know, track your search history to, you know, refine your approach. So for example, if I was researching on consent requirements in Ugandan privacy law, I would use probably some Boolean searches. Okay. For example, I would put informed consent in brackets and data protection in brackets and Uganda. That will give me content that is very specific on informed consent and data protection in Uganda. You get. So that's for example something that you can probably apply. Now, let's look at the second concept or the third concept. Distinguishing between precedents from persuasive authorities. You need to understand that there are those things which binding precedents. So you know the principles of stare decisis, decisions of the Supreme Court or the Constitutional Court on constitutional matters, superior courts. Okay? Those are binding precedent in Uganda. However, at the international level, there is no such thing as binding precedent per se. Okay? So at the international level, most of the things that you'll be arguing will be persuasive at best. No binding precedent. Okay? But at the national level, if you're looking at some persuasive authorities, probably decisions from the ESCJ, decisions from other common law countries, international and regional human rights tribunals, academic commentary, all those would help to persuade whoever is reading as to the gist of what you're arguing. Okay? Now, some of the things that would affect the persuasiveness of something would include similarity. For example, the legal framework. If you have a legal framework in Uganda that is similar to that of another country, that could make that jurisprudence of that country very persuasive. Reputation of the court, okay, or even the judge. Sometimes some courts are very reputable, or some judges are very reputable. Okay, you guys know of Lord Denning, for example, right? That's an example of a reputable judge. Okay, or Professor Lilian Tibatemo Chirikubinza of the Supreme Court of Uganda, very reputable judges. So sometimes if a decision is passed down by a reputable judge or a reputable court, it, you know, it could affect the persuasiveness of that decision, right? Then the quality of your legal reasoning, how do you reason legally? How do you reason your matter? Okay, that could also affect how persuasive it is. And then, of course, sometimes it could just be the context. Okay, the context and applicability of the thing that you're seeking to rely on. All right. So this could be something. So, for example, if you're, for example, looking at a case involving privacy violations, right? Let's say through publication of personal information. You could rely on, let's say, Beinstein and Bester, which is a persuasive authority from, South Africa. Okay. Given by, the South African Constitutional Court. And that decision, because South Africa and Uganda may have similar as if courts, and the South African Constitutional Court is a very reputable court, it could make your argument much more persuasive. Okay. Now, let's look at how you craft a strong legal argument. Okay. How do you craft a strong legal argument? And this can come down to something called structure. Okay. I often tell my friends that sometimes the difference between a good memorial and an outstanding memorial could simply be the structure of that memorial. Okay. So how do you structure your arguments? You've heard of Iraq or Iraq, right? Where you look at the issue, the rule, the application, the conclusion. Okay. That could be a good structure. Other people follow a different structure. Okay. Principle, law, application, conclusion. Okay. That's another structure that you can use. Okay. But get a good structure. Okay. First, identify what this legal question is. Frame it precisely. Okay. Only focusing on your contested points. All right. Then tell us the relevant legal rule or principle. Here you can give us sections of statutes, articles, etc., case law that either established or interpreted that rule. Okay. Then apply this to your specific facts. It doesn't make sense. Sometimes you'll find teams that have a lot of verbiage. They wrote a lot of things, but little of it is in fact applicable at all. Okay, so apply the thing that you've argued to the facts. Okay, show exactly how these two apply. Sometimes you can even draw parallels, okay, to favorable precedents that you like, or you can even distinguish unfavorable cases. Okay, and then make a conclusion, state a logical conclusion. Okay, that's based on that application. Okay, you can tell the court your desired outcome, what you want the court to decide as. Okay, and you then link all of this back to the broader legal principle that you had
Sorry,
discussed
David.
earlier.
So,
Yes,
sorry,
please.
David, for interrupting. You have 25 minutes to go.
All right, no problem. Okay. So I'll give a practical example of an issue, right? Let's say whether a telecommunications company violates Section 35 of the DPPA, okay, by failing to, let's say, implement reasonable security measures to protect a customer's personal data, right? the rule there would possibly be under Section 35, right? That data controllers must implement appropriate technical and organizational measures to ensure a level of security that's appropriate to the harm that might result from unauthorized access to personal data, right? The application of that would possibly be within the facts that you have, okay? And then you make a conclusion whether or not the company violated that provision, right? Now, in all of this, you need to ensure legal coherence and a logical flow of ideas, okay? One, how you organize your arguments. Always start with your strongest argument, group related arguments together, create a logical progression between the points, and use transitional phrases, okay? Always start with your strongest argument, okay? And then put all those arguments that are related together, okay? Have a logical progression between them with transitional phrases, okay? Secondly, you need to maintain your internal consistency. So for example, if you have definitions, make sure they are consistent throughout. Do not contradict your earlier arguments, okay? Maintain a consistent interpretation of the legal principles. Don't interpret something like this in one place, then you interpret it a different way in another, okay? Use consistent citation, okay? Then create a roadmap. Create a roadmap. A roadmap is very important, especially in the first sentences of an argument. Begin with an overview of the entire argument. Use numbered sections, clear headings, mini conclusions after complex sections. Okay? And then when you're done, tie everything together in a comprehensive conclusion. Okay? Now, how would you integrate policy arguments in your privacy cases? Policy arguments are very important. They come from policy. And there are many types. So you have some on economic efficiency, for example, some on technology and innovation, human rights and dignity, public safety. Okay? Use policy arguments only when, one, the legal texts are ambiguous, it's not clear from the law. Okay? Two, when you're dealing with new technological issues. Okay? Three, when you have competing legitimate interests. Okay? Or four, when the precedent is limited or outdated. Okay? And you can only integrate these policy arguments when you're connecting them to existing legal principles, when you're using their data and evidence to support policy claims, when you're referring to international best practices and sort of addressing these competing policy concerns. Okay? So this is how you would create this very good and effective argument for whatever it is, whatever argument that you're advancing. All right? Now that you have created the said argument, how do you write it? How do you make it persuasive and concise? Okay? Let's first look at some techniques for persuasive writing. 1, be clear. Be clear, precise in what you write. Okay? So let's have a bit of clarity, precision, and brevity. So let's just look at clarity. How do you make an argument clear? 1, use simple sentence structures for complex ideas. Okay? Use simple sentence structures. Some of you write sentences that are so complicated. You use words that are so complicated. Use simple sentence. Occam's razor, the easiest way to understand something is the simplest way to understand it. Simple is good. Okay? Then you can define some technical terms and concepts. If there are so many technical terms, you may wish to define them. Okay? And in that definition, you may also benefit from employing some concrete examples to illustrate those principles. Okay? If need be, you can even use some visual aids, tables, diagrams, if need be. Not always called for, but maybe you may want to do that if it's a very complex thing. Then precision. Precision. Okay? Avoid hedge words. That's what's called hedge words. Yeah, such as perhaps, maybe. Be precise. Use specific rather than generic terms. Okay? Cite specific provisions, not just the law. All right? So things like it is trite law. Oh, the DPPA provides without giving us what exactly it provides. According to the Constitution, this is what, tell us where in the Constitution, what article. Okay? Then for brevity, try to maintain one idea per paragraph. Okay? The paragraph should have an idea in it. Eliminate redundant phrases. That are redundant. Okay? And try to use your active voice when you're writing, not passive. It has been said, that's passive. Okay? It is active. All right? Try to use direct statements rather than rhetorical questions. Okay? Don't ask questions in your memorial, rather use direct statements. Okay? Then, how do you strengthen your arguments with legal reasoning? Okay? First, we have different types of legal reasoning. We have what we call rule-based reasoning, that's based on particular rules. Analogical reasoning based on analogies. Policy-based reasoning based on policies. And purposive interpretation based on the purpose or the mischief of the rules. If you want to then integrate facts, okay, always connect your facts directly to the legal elements to which they apply. Don't connect facts at the end. Connect them directly to those legal elements to which they apply. All right? Then you can highlight the determinative facts, the facts that determine the questions. Okay? And then, as a good strategy, you may also want to acknowledge your unfavorable facts. Okay? While this exists, however, you have an alternative. Okay? If you feel brave enough, you can even use hypotheticals to test the rules. Although this is not advisable if you're not very advanced in how you draft. Okay, Sometimes you use hypotheticals and it may backfire. Okay? Now, how do you balance the law and the facts? One, always begin paragraphs with the legal principle. Follow that legal principle with the factual application, the facts, the specific facts that apply to it. Then conclude with legal implications. With the legal implication. What are the implications of that? Okay? Now, using plain language versus legal jargon. Question is, when do you use plain language? I've talked about this. One, use plain language when you're explaining complex concepts. Try to make it as simple to understand as possible. Two, you need to use plain language in your introductory sections. Because if you start off with verbosity and very hard to understand things, you've already killed the mood of the entire thing. Okay.
Excuse me, David.
Then when are you going to go? Yes, please.
You have 15 minutes to go to complete your
Yes,
modules,
please.
both.
Yes, please.
Thank
you. So when do you then use legal terminology? One, when precision is required. And that precision would require you to use a technical term. Okay. You can also use this when you're referring to, say, statutory language, right? Or when established legal texts use that specific terminology, okay? Then you would do well to use, said, legal terminology, right? But in all instances, try to define those technical terms before you use them, okay? Use industry terminology, things that are known industry-wide for technical and privacy concepts. And also try to consider your audience's expertise level, okay? As you make these arguments. Now, how do you avoid some common pitfalls in memory writing? One, avoid redundancy and unnecessary elaboration. You have only a word count, a page count, I think it's 10. You may want to avoid unnecessary elaboration, okay? Some common forms of redundancy that you may look at, that you may understand: restating arguments in multiple sections, excessive quotations, overuse of synonyms and restatements, okay? Restating and repeating a factual background unnecessarily. And how are you going to eliminate this redundancy? You may want to think about creating a detailed outline before you write, so that you know a proper roadmap, okay? Edit your work. Edit your work. Edit your work. When you're done, have it edited, okay? And then you can even use cross-referencing instead of repeating the same thing that you have done, okay? Now, this doesn't mean that repetition is always wrong. Sometimes it can be strategic, okay? Especially if you're restating key themes, for example. Can be in the introduction and in the conclusion. If you're emphasizing certain critical legal standards that you want to be absolutely clear, if you're reinforcing some novel interpretations of the law, okay, or creating some parallelism when you have a particular theory or rhetorical effect that you would like to create parallels about, okay? But in all instances, avoid misinterpretation of legal principles, okay? One, avoid citing cases for propositions where they do not support. Do not misquote, miscite cases. Okay? Do not confuse correlation with causation, especially in precedents. Okay? Do not overgeneralize from specific holdings. And law students are very, very notorious for this. Overgeneralization. There's a particular holding, then you generalize as if it applies everywhere. Okay? Do not fail to distinguish majority opinions from dicta, from dissenting opinions. Okay? How do you prevent misinterpretation? Read the full cases, not just summaries. If you're going to read a case, read the full case, not just summaries. When we are judging, we often land on people who did not read the full case and they're trying to mislead the court. We often catch them. Okay? Trace the legal principles to their original sources. Okay? Consider the factual context of cited cases. Sometimes the case is absolutely not applicable here because of the factual context in it. Okay? Okay? Try to update your research with recent developments so that you're not out of date. Okay? If there are multiple interpretations, you can acknowledge them. Okay? But of course, present the strongest interpretation based on the authority that you're relying on. You can also address some alternative interpretations, if there are any, okay? And sometimes it could also help you to look at the legislative history, especially for statutory interpretation or the travaux préparatoires, the preparatory documents for treaties, okay? You may want to look at some of those, okay? Then you have weak counter arguments and rebuttals, okay? How do you know that you have a weak counter argument? One, if you're presenting straw man versions of opposing arguments, you know what a straw man is, okay? Straw man versions, or trying to straw man the other side. Two, if you're only addressing the weakest opposing points, not the strongest, but the weakest. Three, when you fail to acknowledge the strongest opposing authority, okay? Or when you dismiss counter arguments without a substantive analysis. You need to analyze before you dismiss, okay? How then would you go about counter arguments properly and effectively? Okay? One, you can start with, for example, accurately stating the opposing position, okay? At its full strength, acknowledging if it has any valid aspects to it, then identifying any specific flaws in that reasoning, and then presenting your own superior alternative interpretation. That's how you do a proper counter argument. How about questions of rebuttal in your memorials? One, you may want to show why opposing precedents are distinguishable. That's distinguishing of cases, right? And then you can also demonstrate any logical inconsistencies in the opposing position and precedents, okay? Then present your own countervailing policy considerations, okay? And you may also highlight some factual inaccuracies, okay? In what the opposing position might be, okay? Now, some key points for you, understand. The importance of jurisdiction-specific research, Okay, talked about if it's Uganda, if it's an international court, etc. The value of systematic research. Okay, begin with the constitution or the treaties, etc. That logical flow. Okay. Persuasiveness and binding authorities. Okay, precision and clarity, and the effectiveness of integrating technical understanding with legal principles. Okay. So yeah, I think that would be it for these two modules, and those I think would be the tips that could help you, unless there are any questions that I can take on in the remaining few minutes.
Thank you, Mr. Kasibante. To our dear participants, please, do you have any questions? And as you think about them, I want to just appraise that most of your questions that you earlier on had, especially for the structure and the mooting and the memorial format, answers have been put into the chat room on the respective individuals that raised them. So just look out for those responses as we move forward. If there are no questions, then I would like us to move. Okay, Jonathan, there you are. Over to you, David.
Yes, Jonathan.
Okay. Thank you very much for the opportunity, and also thank you for the good presentation that you've just done to us. Mine is one question, and throughout the presentation, you've been insisting that we need to use binding authorities, especially decisions of the court. In this particular case, we are appearing before the East African Court of Justice. So what would be the binding authorities that we can use? Then secondly,
yeah, okay, let me just, okay.
Secondly,
Yes.
I don't know whether it is tied to my earlier question, but you realize that in the rules and also the moot fact, you realize that there is no particular mention of the laws of the Republic of Azimia are similar or analogous to any other state in the East Africa. So in the event we decide to use maybe the Data Protection Act of Uganda or Kenya, on what basis are we using it?
So your question is on binding and persuasive authorities. So I mentioned that binding authorities would only apply if you're appearing before a national court. International courts typically do not have binding authorities. So what you have, apart from their own protocols and their own rules, okay, those could be binding to that court. But beyond that, they typically do not have binding authorities. In fact, all cases and authorities that you typically bring will be persuasive at best, apart from the treaties that the state has signed. Those treaties are binding on that state, okay? Now, so if you're before the ESCJ, the authorities that you'll be relying on will be mostly persuasive at best. And since the country or the state does not have any ties to any, I mean, they haven't told you its laws are immaterial with any other, then when you are to make your work persuasive enough, you may want to look at its, the context of that state, okay? Its socio-economic context, its location, etc. And use those things to draw parallels with good laws that exist within those jurisdictions, those areas, okay? So if it's before the ESCJ, I would probably presume that's an East African country, right? So you may want to look at different laws from different East African countries and what they say about the particular issues that you're arguing. And then you use those laws as persuasive authorities to persuade the court that, see, even in this country, in Kenya, this is what they are doing. And this is also what's happening in Rwanda. This is also what's happening in Uganda. You know, drawing those parallels to help the court see, okay, what is happening in different areas and whether or not it should apply those things within its own jurisprudence. Okay, so that's what you would do. Are there any other questions, comments, or concerns? Right, if there is none, I will yield the floor back to you, Freda. Thank you very much.
Thank you so much. Thank you so much, Mr. Kasibante. We really appreciate your expertise and the elaborate presentation and the experience, the wealth of experience that you bring on board. At this juncture, I wish to invite our next facilitator, Ms. Rufaro, to take us into the next 2 modules. And she's already online. Rufaro, you're welcome. And over to you without wasting any time.
Okay, all right. Thank you so much, Freda. And thank you to David. He's done a lot of work. So some of it, I think I will, for the sake of time, I will just, let me share my presentation first. We can all see, right?
Can you slide show it?
Okay, let me try to slide show it. Okay. Yes. Is it now showing well?
Yes, Rufaro. Many thanks.
All right. Okay. So my presentation is on referencing what the other lady was asking about referencing, and I'm also going to touch on reviewing and editing and perfecting of a memorial. So the good thing is that we already have a foundation as to sources and the like. So I will just go ahead and continue. So what we're going to focus on when we're talking about referencing and citation and authority, when you're writing our memorials and our submissions, is that we need to know what best practices in legal citations are. And this has been summed up as properly citing statutes, cases, academic literature, avoiding plagiarism in legal writing, how to format your footnotes and references professionally. Okay, I'm trying to move my slide. So the purpose of referencing is that it serves to ensure that your work has got integrity, and you provide evidence for your claims, and you acknowledge the contributions of other scholars. And it also gives credibility to your work as an author. So I've listed it here, acknowledging other scholars' work, demonstrating academic integrity and avoiding plagiarism, demonstrating understanding of the topic and field, providing evidence, supporting arguments, enabling readers to verify information and build upon your research. So if you don't reference your work, it loses credibility and integrity, because we always when I was doing my studies for my postgraduate, we always used to joke about how you cannot say bread is white. You have to say, according to Smith in 2002, it was established that bread is white. Why? Because your work always needs to show that you've researched well, you've researched extensively, and you are knowledgeable as to who are the best authority in the industry. When you look at data protection, for example, you need to know who is the authority in data protection, who is the authority in constitutional law. And once you know that, you know where to start and you know how to build. Even all of the things that David was referring to, you will understand where you're starting from and where you're going. And it makes your work more authentic, and it makes your work have depth, and it makes it even more interesting for readers to follow through, because you are backing up your arguments with identifiable authority, with scholars who are respected in the industry, with scholars who have established their footing in the industry. So this is one of the purposes of referencing. And now moving on to referencing styles. So there are several referencing styles across the board internationally. The most popular, I should say, is Harvard referencing, and Oxford referencing comes after Harvard referencing. And you will find that most institutions across the world, they actually use Harvard referencing, and most institutions in Africa prefer Harvard referencing. Of course, we've got other institutions like the University of Johannesburg that has created their own special kind of referencing that is peculiar to them. But you will find that most of the institutions across Africa actually prefer Harvard referencing, and some prefer Oxford referencing. So when you find yourself in a situation where it has not been stated as to which referencing style you should prefer, it's always safe to go for the Harvard referencing. Why? Because it is the most internationally recognized form of referencing. And for me, I would say, to be honest, is the easiest one. Because maybe I've used this over a long time, I can now use it even in my sleep, as it were. Why? Because it is so clear and easy to follow. So when you're using authority, how to use authorities effectively, like what I was saying before, you need to have researched extensively and you need to know your topic very well. What you're writing about, is going to be difficult for you to know where to start. And you need to organize your thoughts logically and clearly, precisely and concisely, using language that is simple. I like the fact that even Freda mentioned this. Gone are the days when we use legal jargon. Here in Zimbabwe, we call it being verbose. You don't have to be verbose. And I know lawyers generally, whether you're a law student or you're a lawyer in practice, people love to use flowery language and to be complex and complicated and show that, no, I'm a lawyer, I speak with authority, but you have to be careful in how you're expressing yourself. So this is one of the things that is very important, because when you are now articulating what you've researched and you're trying to also reference it and use it in your work, it's important to use that simple language and to reference properly and articulately. And when you anticipate and address counter arguments, the use of authority makes it even more authentic. And adding your own opinion and voice to the argument helps to make your work more credible and original. So quickly, getting into the Harvard referencing. So it's important to identify the source first and finding a matching example. For example, consulting a style guide. You note that I have gone through your moot guidelines, I've not seen it going word for word as to how you're going to reference this. So you can even search on the internet for a Harvard referencing style that can assist you. I can refer you to the University of Pretoria. I studied there, and they also have on their website the referencing in detail as to how to do Harvard referencing. You can also go to University of Fort Hare website. They also have a detailed account on how to use Harvard referencing. But in my slides, I've touched on a few sources to assist you on where to start. So when you're doing in-text referencing, so in-text referencing is also called in-text citation. This is where you are citing or what you found in, for example, I've used these 2 textbooks. I actually do have them because I thought maybe it will be easy for me to use those ones because I actually have those textbooks. So these are data protection law textbooks. So Papadopoulos and Snellcam they wrote a textbook on information communications technology law. It was published in 2022. It was actually is titled Cyber Law at South Africa, the Law of the Internet in South Africa, and it was published in 2022. This one is actually a 4th edition, if I'm not mistaken. And so when you're referencing it in text, right, you're referring to what it is that they're saying about data protection that is going to, you're using what they're saying as an authority in your work. So you're expected, when you're using the in-text referencing, to cite the name of the author and the year only. It's different from when you're using footnotes. I'll show you when you're using footnotes what you do. So when it's a journal article, I also used a journal article that I actually have by Professor Watney. So you cite the author and the year as well. This is for in-text referencing. So when you're using in-text referencing, it's supposed to be simple and to the point. And obviously, when you're quoting what this person has said or this author has said, you're expected, if you're using verbatim, you're quoting them verbatim, you're using word for word what they said in their work, you are expected to use quotation marks. To say Watney said, you put quotation marks, you quote what they said. But if you're going to say according to Watney, then you're expected at the end of the sentence to then put in brackets Watney, then you put the year, like the way I've shown you there. And then when you're referring to a newspaper article, I had to use my name because I didn't want to use a specific newspaper article. I just thought it was easier. And then the Herald is a publication that is available here in Zimbabwe. So when it is a newspaper article, you are expected to put the name of the author and the year in brackets. And if that is if the name of the author is known. If the name of the author is not known and they have not, the editor has not mentioned who the name of the author is, then you have to just say the Herald and then you put the year. And this is still in text referencing. So this is basically what is expected of you. And if it's online, it's the same thing. So you will note across the board that when it comes to in-text referencing, is the same thing that is required of you. Now, when you're using footnotes are a separate system altogether from in-text referencing. It means that you cannot use in-text referencing together with footnotes. You have to choose either in-text referencing or you choose footnotes. When you choose footnotes, it now means that you then go to the footnote and then you write, for example, what I've done there when it comes to a book. You write the name of the author in brackets, the date, the year, and then you put the page number where you found the information that you want to quote. Right, and that applies to newspapers, articles, and when it comes to journal articles, you are expected to reference the same way you would reference when you're listing now on your list of references, and I'll show you how you do it in a moment. So when it comes to list of references, now you are expected to give a full citation. When we say full citation, we mean the name of the author, the year when the book was published, the title of the book, the place of publication, and the publisher. That will be the publishing house. And you find this normally on the first page of the book. If it is an ebook, I would advise you to click on the cover page, and it will actually direct you on the citation of the book. Normally, when you're dealing with Amazon, I think Kindle, it actually helps you with the proper citation of the text that you want to use. If you are using an ebook that you found on the internet or you bought on the internet. Because even if it's from the internet, guys, you still must reference that author. Don't take it for granted that no, it's on the internet, so I don't have to. You must include that citation, even if it's an ebook. So if it's an ebook, it means that you are expected now to go a step further. And after where I've written the publishers, now you are expected to say, to write the hyperlink, https://www.amazon.com, and then /ebook. I'm just giving an example. And then you write in brackets, accessed on 14 May 2025, because you must show when you accessed it. Because if you don't, it is assumed that you never accessed it. And I'm sure your marks will actually be deducted for that. So for journal articles, you also do like what I've illustrated there. You write the author, the year, the article title, the journal name, the volume, and the issue numbers. So this one, I had to go an extra mile and just include other things because some of the information was missing on it, on the face of the journal article itself. So I had to come up with a hypothetical one. So please don't go try to look for it in the juris, because you will not find such a thing called the juris, and that volume number is made up. Then when you're dealing with newspaper articles, again, you start with the author, the year, the title of the article, the name of the newspaper, the date and month, the page number. And this is how you're expected to put it across. And when it comes to the title of the article, it must always be in inverted marks. Why? Because it needs to be on its own, standing out to show that this is the name of or rather the article of the title of the article. Then if it's an online newspaper article, like I said earlier, you're expected to then add the
Rufaro, we've lost you. Rufaro, we've lost you. But in the meantime, as we wait for our facilitator to get back, I'm pretty sure it
Apologies,
must be
guys. My network just dropped. I don't know. what happened.
It's okay. You could just recap briefly where you stopped from, and then we continue.
I hope you're hearing me clearly.
Yes, we do, Rufaro.
Okay, all right. So let me try to move forward to where I was, where I left off. Yes. So the last part of us on citation, referencing and
Rufaro, we've lost you again. As we wait for Rufaro to get back, please check through the chat box for responses to some of the questions you had. And at this juncture, I was wondering whether, do we have any questions up until this time? Or is there a question that is burning that we have not yet responded to? We could use this opportunity as we wait for Rufaro to get back. All right, I will use this opportunity again to clarify on the citation. This came up prominently in the chat box, and we had specified as to what you should use. So you can use Oxford citation or Scholar, and then also Rufaro made mention of the citation being used at the University of Pretoria. That is also something that ties in as well a bit with Oxford. So if you can just work closely around with that, then you'll be good to go. Rufaro, you're welcome.
Thank you, Freda. Yeah, today the Zimbabwean subscriber decided to embarrass me today. I'm really sorry,
No problem, guys. No problem.
Yeah. Okay. So where we were now, so I was talking about how to resolve a conflict between authorities. So it's important that when you come across authorities that are conflicting, they've got two different opinions on the same subject. It's important that you then give those two conflicting opinions, you put them across plainly, and you cite who is who. Whether, I'll give an example, maybe it's I'll say Mandu and versus Smith's opinion. You have to give both sides, and then you either choose which of the two schools of thought you're going for and why, and you have to give the reason why, or you can come with your own independent conclusion to say, okay, Mandu says this, Smith says this, but I am of the opinion that A, B, C, D, and you have to back it up. So that is on referencing. So now to move on to the next thing, reviewing, editing, and perfecting your memorial. So on this one, it's important that you have your checklist. You have your checklist for the reviewing of your memorial. And I'm glad that you already have a criteria. So your criteria should be the first port of call. You should include it on your checklist. And I've come up with a checklist that you can actually use as a guideline. This is just a guideline, guys. You can come up with your own. It's always good to come up with your own, but this one is just a guide. So the structure, on the structure, I'll replace it with the criteria. I'll say the criteria that you've been given. And I noticed that it's on Article 24, and it will assist you to know what is expected of you. And then the second thing are the parties, to check, okay, do I have the parties cited correctly? Have I cited the parties correctly? Do I not have any typing errors there? And then my cover page is correct, my table of contents, abbreviations, my legal question, is it making sense? Is it tallying with what was given as the assignment? My argument, is my argument coherent? Authorities, you just then check. And I'm glad that you know, we are going through this exercise so that you can then also juxtapose the referencing style that we've shared on the authorities that you're going to check, whether you have all the authorities that are sufficient, and whether you've done things properly, whether you've not done plagiarism. And you can even use Turnitin on this one. And then number 9, footnotes. And I'm glad that Article 23 of your moot court rules and regulations speaks to the font and the format that is expected of you when you're doing footnotes. And I noted that they say Times New Roman, 1.5 spacing, and I think it's saying 10 font, 10 size font. And then you also check for grammatical errors and structural errors. So diving into the common grammatical and structural errors. So I'll share this slide so that you can go through what it is saying. So the first one that I've seen, even when I'm doing editing, in instances where I'm asked to do editing, because I also do editing sometimes, you will note that, hey, this is a very common error. I've given an illustration. The attorney loves positivism. It's his argument, right? It's not one sentence. Those are 2 sentences that have been joined together and they need to be correct. And so the correct way of putting it across is either using a full stop or use a semicolon. You cannot use it as just one floating sentence that is fused together. Yet there are 2 separate phrases that are combined in one sentence. Then the use of a comma. Again, when you're splitting thoughts or you're splitting phrases, you just don't throw in a comma and you leave it there. You need to put the proper coordinating conjunction, whether it's a but or an and, after your comma, like what I've illustrated there. Luke went to the police station, he made a police report. You need to put a comma properly. Luke went to the police station, comma, and made a police report. Then misplaced letters and wrong spellings. Here I made a deliberate error to show you what I was referring to. Many writers make this error, including myself. I've made this error when I was typing my heads before. It was only after I had actually submitted that I realized, oh my goodness, I typed sometimes and it is a 3 in the middle or a 9 in the middle. And in this instance, trust me, Word document will not pick it up. So this now goes to how articulate you are as a writer. And if you put it to someone else to assist you to edit, they're going to assist you to pick this up. And another way to easily pick it up is if you convert your Word document to PDF, it makes it easier to read and you can actually pick up these mistakes. So when you read this sentence, it will be interesting to take a poll and see who managed to notice my typing error at the first, within the first 5 seconds of reading it, when I put in that 3 at sometimes there. Then subject verb agreement. This one, guys, it is a problem that we have. English is not our first language, and I see that we struggle with this one a lot, but it's very important for us to assist each other on this one. So I put the wrong subject verb agreement on the left and the correct one on the right. You'll find that someone, even when they're talking, you'll find someone can even say, I concurs with that argument. No, it's I concur. So it's very important for us to get this one right. And your ordinary autocorrect will assist you to correct this one. Then the passive voice, like David alluded to earlier on, it's not fun to be reading a memorial and it's speaking in the passive voice. It actually distracts you as a reader. So it is always good to be engaging your audience. And the best way to engage your audience is to use the active voice. The decision was made by the Honorable Justice Mandu. No, that's not how you put it. Honorable Justice Mandu made the decision. That's how you put it. And then incorrect word choice. This can happen when you're now tired. You've been writing your work, you've gone through so much research, you're thinking, okay, let me get this done. And this is very easy to make this error. This one, I genuinely think that when it comes to lawyers, it's not about us confusing the words, it's about a genuine typing error. Because I've even done it, even myself, I've used the wrong word. You want to say the legal question is whether the defendant has the legal right to occupy the plaintiff's premises, instead of using the second one that I've used in the second sentence. So it happens a lot, but you only get to notice these things once you edit, when you're editing your work closely, and you even ask your peer to assist you with the editing. And then with the vague nouns, this one, we are very good at doing this with being vague. I gave this example. Farai and Taurai left the courthouse after he finished his case. Who finished the case? Farai and Taurai left the courthouse after Taurai finished his case. You'll find that when you're doing arguments, this is usually done when someone is trying to maybe put across a statement or a research statement from their research, to say maybe the local authority did A, B, C, D, and after that they finished their work. Who finished their work? We have to be precise. And then misplaced or missing apostrophes. This happens a lot. You want to talk about a lot of girls who were involved in a petition that lawyers drafted and they filed on behalf of the girls. And then instead of using the apostrophe in the proper manner, someone can do it in the way that I first gave the example. We filed the girls' petition, no apostrophe. We filed the girls' petition, which is not proper. So the correct way is putting it after the girls. Then a dangling modifier. Well, this one is when you are being very colorful with your statements. You want to put across an argument in a compelling way, you are trying to impact to draw the attention of your audience in an impactful way. And then you put it in a way that it doesn't make sense. Why does it make sense? Doesn't make sense. Let me demonstrate what I'm talking about. While occupying the office, thoughts of resigning were consuming the chairperson. So here you're basically saying that the thoughts of resigning were occupying the office. It, it doesn't make sense, especially to first language speakers. They're like, what do you mean thoughts of resigning do not occupy an office? So is the subject that has to start before the verb, right? So while occupying the office, the chairperson was consumed with thoughts of resigning. That's how you put it. And I could give several examples, but for the sake of time, let's work with this one and just understand what we're talking about here. And then incomplete thoughts or missing words. This happens a lot when you're now tired. This is typical of, when you're tired, now you just want to go through the work and you want to finish already, and you write a statement that when someone else reads it, it doesn't make sense, and they wonder what you're talking about. And in any event, the one that I actually gave actually makes better sense than some of the statements that I've seen written on this one, and that I've even written myself sometimes. And then when I'm re-editing, I realize, oh my goodness, I left out words and phrases that make the statement make sense. So here we say it is the argument of the accused no lawful right to claim ownership of the property in question. It can kind of make sense of what they're trying to say. So when the missing words are then included, that's when it makes more sense, or actually make the actual sense that you're trying to put across. It is the argument of the accused that the complainant has no lawful right to claim ownership of the property in question. So, yeah. So, how do we assist each other on refining? We just decided to go with the best practices for last minute refinements. So I listed them this way. You go back to your checklist and tick off tasks. So if you have not written it out in longhand somewhere so that you can tick it off, you cannot do it offhand. You're going to miss something. So it's important to have your checklist, write it down for yourself. When you start formulating your work, or you are at brainstorming phase, whichever technique or strategy you decide to employ in order to come up with your memorial, it's important to have your checklist at the onset of writing your memorial. And then as you're going along with your work, that's when you tick off. So in your checklist, you can even include the research aspect. That's why I included on that checklist authorities. You can even include your research to say, okay, I've done the research, I've done the extensive research, I've covered all the authorities that are recognized within this space of legal practice, or these are the thought leaders in this area of practice, or in this area of in this subject area that, or this thematic area that I've been tasked to tackle. Then the next thing is you need to adopt all reading techniques to go through your work. So we've got extensive reading, where you read a huge document, and then there's the intensive reading, which you use on short pieces, you zero in. And here, remember, you're expected to come up with a 10-page work. And in terms of legal writing, that is relatively, depending on who's talking, that is relatively a short piece. So you're expected to read it intensively so that you check for those errors that you would not notice if you're just scanning or skimming or the like. So that's why I said you need to adopt all reading techniques. You're scanning, you're skimming, oral reading. Oral reading helps you to have that voice that the reader has, and visualize and have that thought process of, okay, this is what I'm talking about. Does it make sense? And if you're not good at reading out loud to yourself, you can use artificial intelligence reader. you find that Adobe now has a artificial intelligence reading where you can choose whichever accent you want, whether it is in your own local. I was surprised they actually have a variety of accents to choose from. So you can actually use that one to read out your work for yourself. You just convert your Word document to PDF and it will read for you out loud. And then it's also important to run your work through an application that helps you to correct your grammar effectively. Use Grammarly, or you can use Pro Writing Aid. There are a lot of applications that you can use out there. You can also have a peer review your work, which is really recommended. If you've got a colleague, I would suggest you have 2 colleagues to peer review. The first one, it can be an engineering student. When I say engineer, I'm just giving an example. Someone who is not a lawyer, to read your work so that they give you an objective perspective to say, is your work simple enough for them to follow? Is it logical? Is it something that someone who does not have a law degree or who is not studying towards a law degree can actually understand? Once you can have someone who is not studying a law degree able to understand your work, you've done a great job. So you then have your legal friend, who's not part of the moot, obviously, to review your work. And that way, because they also have that legal background, they can assist you with those authorities that you might have missed, who are the renowned, authentic thought leaders in the thematic area that you're tackling. And then you need to read again. Read again your work. And the secret behind this is, if you work on a document today and you read it today, trust me, when you work on it tomorrow and you read it again tomorrow, you're going to come across errors that you did not notice today. So it's important to continuously work on your document. If it means you give yourself 30 minutes a day to edit your work, the better. Why? Because you're going to come out with something that is really good and authentic. So that comes to the end of my presentation. I know we were going to do a live review of a session with expert feedback and see sample arguments for critique. These ones I actually have, I don't know, Freda, if you've got time to do this, because I have an example that I had picked out from the international moot court that was done previously. I don't know
Sorry,
if we've got time.
You have about 15 minutes. So yes, you can go ahead.
Okay,
Yes.
great. All right, guys. So let me just stop sharing this one and see if I can. Okay, if I can share. Okay, sorry guys, now my technology is, all right. So this is the International Media Law Moot Court competition. Memorials. These were the best. So I then picked out from the best applicant and the best respondent. So as you've noted from your guidelines, you were told that the applicant must have yellow, or I'm mixing up, but either the plaintiff and the defendant, your covers should be either green or yellow. And this is the example. As you can see in this moot court, the applicants had a blue page, and this is what the layout was expected of them, right? And they were expected to have the word count there. So let's go down to their referencing style. So this guy's yes, this guys had footnotes, right? So they were not using in-text citation, they were using footnotes. So I'll give an example. As you can see there, the first footnote is coming right after the full stop, as you can see. And then when you go down, you see that that's where they've done their footnote and they give the page number and everything. But in this case, I'm seeing that this was an article from a convention. So you'll find that the way you quote a convention, statutes and treaties is so different from the way you would quote, say, case law. So let me see where they quoted case law so that I can give you a practical example. Okay, this one I'm not seeing. Okay. All right, there we go. So as you can see, this one used a lot of case law. You would understand why they were the best. It's really showed that they extensively researched. So as you can see from their statement, for an interference to be prescribed by law, an act must be accessible and reasonably foreseeable. And then they put the footnote right there. And that's 50, footnote number 50. And as you can see on footnote number 50, they've got a lot of case law that they've included there. And you can see like it's so evident in their work that this person extensively researched. They took their time to really do research.
Sorry, Rufaro.
Yes.
Unfortunately, I think you're sharing the wrong screen because there are complaints that they can't see. I don't know.
Oh, they can't see.
Mm.
Okay. Let me. Oh, sorry, guys. Can you now see? Is it now visible?
Yes, now it's visible.
Okay, I'm sorry, guys. Yeah, imagine a data protection lawyer. Having such glitches. Okay, guys. So going back to what I was saying, okay. So there is the sentence that I was referring to. For an interference to be prescribed by law, an act must be accessible and reasonably foreseeable. So this shows this is a good writer, a writer who acknowledges that this statement, I got it from several authorities. And then to reflect on those authorities, they give their footnotes immediately after this first ground. And then on foot number 50, the one that I was referring to right there, I don't know if you can see my mouse. They've got a number of cases there that are supporting what they're saying, including UNHRC Article 34, actually Article 19. You know, they've gone an extra mile to do their research and to make sure that everything that they have done has got a backing from authority that they researched on. I don't know if I'm allowed to share this with you guys. Freda, are they allowed to have a precedent from the other one to really show how others do it internationally. So as you can see on this paragraph number 6, first, it does not use strict and unequivocal terms, clearly restricting any punishable behaviors to support what they're talking about, where they got that from. They put a footnote there, footnote 58, and the footnote is showing all of those cases that they researched on, that are speaking to that statement that they've given. And then when we go to their list of references, let me check where they put their list of references. Because these guys, their format is a bit different from what others do, where they put it at the end, some put it at the end, some put it before. So as you can see, yes, so list of sources, authorities there. So they started out with the declarations and treaties and conventions, like what David was alluding to, that when you're appearing before an international tribunal or a regional tribunal, you're expected to go for the protocols and the declarations and the treaties and conventions that are applicable to that jurisdiction. So that is your starting point. So this is why you find that they started out with the declarations, the treaties, and the conventions. And these guys were intentional about this, to say, this is to show the reader, this is where we started out in our research. And although it's not a hard and fast rule, but these guys were intentional. I guess this is why they won the best memorial, because they were intentional. They actually showed where they started out with their research. And then they go on to case law, and they have got a lot of cases, guys, a lot. And so this is why they separated them. As you can see, they separated cases from
Sorry,
the
for
UNHCR.
5 minutes to go.
Okay. And then
Yeah.
they also, yeah, so I guess you can see what I'm talking about, that these guys were intentional. They separated case law because they had a lot of cases. They even separated jurisdictions of the cases. And yeah, I think maybe I can go to Q&A because we don't have time, guys. I would have loved us to go through this more extensively, but I think maybe I can give you a chance to ask questions.
Thank you, Rufaro, for the elaborate presentation. At this juncture, in the interest of time, because we are really determined to finish on time, for those who have questions, you're welcome to make your questions right now. You could also use the chat. We are closely monitoring the chat. You could also drop it over there. But otherwise, we would also give opportunity to those who want to speak. Just simply put up your hand and we will give you the opportunity. We have 5 minutes to do this.
I'm seeing someone is asking in the chat, how can we get the documents she has just explained?
Like I have intimated earlier on during the course of yesterday and even today, we will be sharing the presentations with you at the end of the boot camps. So please don't worry. We will share with you these presentations.
I hope I was not going too fast, such
No,
that
Rosemary,
people didn't get what I was talking about.
no. You're doing great. So do we have any more questions? Well, I'm going to treat it like an auction, going once, going twice, going thrice, and that's it. Okay. I want to take this opportunity to thank you all, our dear facilitators, Mr. Kasirante, Ms. Rufaro, and at this juncture, Ms. Rufaro, you're off the witness box. But thank you so much for sharing with us the experience that you have, and I'm hoping that our participating teams have benefited. As we draw to a closure of today's bootcamp, I just want to emphasize the following. And first of all, in regard to your memorials, they should be presented in compliance with all the relevant articles in the moot rules. So please, again and again and again, I'll say this, please acquaint yourself with the moot rules. Please visit our website, www.uwmoot.com, and download a copy for yourself. Read these moot rules religiously. They will provide you most of the key things that you need to put into consideration as you prepare your memorials. Obviously, with today's bootcamp, officially you're being flagged off to start preparing your memorials if you haven't, start reading if you haven't, the research should start, because you have up until 27th of June, it will be a Friday, when you'll be submitting, and you can submit either on that day or just before 23:59 hours on Friday. So you really have to be on time. Any late submissions will not be accepted. I want to emphasize the fact that the top 4 marks of the memorials in each country will be the ones qualifying to or will earn the ticket to get into the national rounds. So memorials in each country will be graded from 1 to 4 after being marked, and obviously applying also the penalty marks. So the top 4 will be arraigned, and these are the ones that will qualify for the national rounds. Final marks for the memorials will include penalty deductions if your memorial is such that there is non-compliance on 1 or 2, 3 aspects. And so the final mark will come after the penalty marks or penalties have been applied. Once we have all these final marks in, we will make an announcement of the top 4 marks for each country, and this will be done on 3rd September. So for you to be able to know who is going to the national rounds. So with this, I want to thank you, all of you competing teams. Please pat yourself on the shoulders for the good participation. I urge you to come back tomorrow again, same time. We have another session on oral presentation and litigation. So this is also very critical to prepare you for the the phase of the competition on oral submissions in September. So this is very critical. It's pertinent that actually you do participate tomorrow. Let's keep time. We are having problems starting exactly at 2 because by the time we open up the virtual platform, some of the teams have not, usually have not joined. So I urge you to please keep time so that we can end on time. With this, I would like to bring this meeting to a closure, and I'm being drawn to a question that has been put in the chat box. Could you guide us on the optional annex? Your question is not clear. If you don't mind, you could stay back and we can engage in the chat room. If you could just clarify on exactly what you mean by the optional annex. But otherwise, for now, I would like to bring this meeting to a closure and wish you a good evening. Thank you so much. Bye for now.